a su disposición en la página web de Secretaría General de la UGR en el apartado de protección de datos. Las personas que no deseen ser grabadas podrán acomodarse en la zona delimitada fuera del campo de grabación. Buenos días a todos de nuevo. Hoy tenemos el privilegio de poder contar en esta sala con el profesor Luis de Koker. El profesor Luis de Koker es el titular de una cátedra de Derecho en la Facultad de Derecho de la Trobe, en Australia, donde es coordinador y líder del programa RegTech del equipo de la Universidad de la Trobe sobre Derecho y Tecnología. Es consultor principal de política de delitos financieros del Grupo Consultivo de Ayuda a los Pobres, un grupo de reflexión independiente con sede en el Banco Mundial que promueve la inclusión financiera. Luis fue antiguo director del Centro para el Estudio de los Delitos Económicos de la Universidad de Johannesburgo. Ha trabajado con el Grupo Consultivo de Ayuda a los Pobres, el Banco Mundial, la Alianza para la Inclusión Financiera y los reguladores y proveedores de servicios financieros en materia de integridad e inclusión desde mediados de la década del año 2000. Ha asesorado sobre una serie de leyes y reglamentos en países como Jordania, Kirguistán, Namibia, Sudáfrica, Uganda y Vietnam, y sus investigaciones sobre las leyes de integridad y su impacto en la inclusión financiera han sido citadas en publicaciones de diversos organismos internacionales como el Banco Mundial, el Fondo Monetario Internacional, el Grupo de Acción Financiera Internacional y el Comité de Supervisión Bancaria de Basilea. Ha sido miembro de un equipo del Banco Mundial que ha investigado los controles de los delitos financieros relacionados con el dinero móvil, miembro del equipo central que diseñó la herramienta del Banco Mundial para la evaluación del riesgo de blanqueo de capitales a nivel nacional y miembro del grupo de proyectos que redactó sus documentos de orientación sobre la alineación de la inclusión financiera y la integridad financiera y la orientación sobre la identidad digital. Entre sus libros más recientes figuran Financial Technology and the Law, Combating Financial Crime y Money Laundering and Terrorist Financing, Law and Compliance in South Africa. Desde el 2014 hasta 2019 ha sido líder nacional del programa de investigación de Derecho y Política con una financiación de 1,8 millones de dólares australianos del Centro de Investigación Cooperativa Data to Decisions, financiado por el gobierno australiano. Un programa que considera los aspectos legales y políticos relacionados con el análisis de Big Data y los objetivos de seguridad nacional de Australia. Para mí es un privilegio poder presentarlo hoy y dándole las gracias también al profesor John Zeleznikow por, digamos, atraer al profesor Luis de Koker hacia la Universidad de Granada. It is a privilege for me. I'm going to speak English now for the audience English speaker. I thank a lot Professor Luis de Koker to be here today, even taking into consideration all the incidences that were with the air floods things. And all the to make it easier to be here today to speak with us in this interesting topic for our research unit. You have the floor, Luis, please.
Ms. De La Rosa, thank you so much for that very kind introduction. Ladies and gentlemen, I feel very privileged to be in Granada. This is the first time for us as a family to visit Andalusia, and what a wonderful visit, and to be able to take up a bit of time also to meet with you and to have these discussions is really precious. Made even more so by the wonderful fact of having my colleague, Professor John Zeleznikow, here, and not only seeing them, but building these bridges, institutional bridges, that we really appreciate. Thank you so much also for your flexibility, dealing with all of the uncertainties around the strike at the moment, and my own travel arrangements that got caught up with that. I really appreciate it, and I appreciate this opportunity to have this talk, because I think especially with the work that John is doing and work that I'm doing, that there may be possibilities of further bridges into the important work that you are also doing. What I want to discuss in the broad is what is known as AML, CFT, anti-money laundering and combating the financing of terrorism, and the rise of compliance technologies. Now, I have made my slides richer than I normally do, especially to assist with language. And so please feel free to move closer. I realize it's fairly small on the screen. But I actually want to build on that to move to what I view as a next wave of challenges regarding proliferation, or let's say proliferation of weapons of mass destruction, and the challenges to be navigated using technology. I'd like to point out, just in terms of relevance, that just a Google search on the terms AML, CFT, and AI generates kind of close on 2 million hits. So from that perspective, it's a fairly hot topic. Google Scholar, much less so, only 1,600. But for academic papers and student papers, that's not bad, especially given that more than 600 of them have been published since 2021. So the idea that here's a rising trend that's worthwhile to take note of. Certainly, the global standard setters, and I'll focus on one, but there are more, have been producing an increasing number of papers around AI and financial regulation. And I noted that Telecom Paris, working with the Institut Polytechnique de Paris, also established a chair in AI explainability in AML CFT. So although this is a very interesting topic, and I think very important topic for me, I wanted to give you a sense that I'm not alone in this space, and it's well worth thinking how your work ties into this area. The why of this particular topic also links to a current project that I'm undertaking. There are brand new standards on proliferation financing adopted by a fairly powerful global standard setter. And I'm doing what I'm normally doing, and I'm looking at the impact on smaller economies, developing economies, low capacity countries. There's a specific belief in this space that the complexity can be increased without limit, because technology will come to the rescue. We will have reg tech and sup tech, so regulatory technologies for compliance, supervisory technologies, intelligence technologies, law enforcement technologies, and that will solve all of the problems. And I'm discussing this with key role players in the system and extracting their views. Currently, I am very honored to be hosted in Spain by the UAB, but also by the IIIA of CSIC as a visiting professor. But this morning, it is wonderful to be visiting you and to perhaps tie some of you into that broader discussion also in this context. So, starting point. In the 1980s, with the Cold War coming to an end, and with the former Eastern Bloc countries and the former West, as defined during that age, they started to compare notes on terrorism and also on crime, even before the Berlin Wall fell. And in those discussions, they started to get very concerned about the rise in terror threats, but also the rise in organized crime threats. Now, that was also linked to the rise of organized crime due to the cocaine trade and an incredible wealth built, especially by South American organized crime. And it was decided that a new strategy was required to combat that type of crime. And what they essentially adopted was one based on what was defined as the business model of crime. Organized crime syndicates were viewed as businesses. And the best way to disrupt a business is to disrupt the flow of money. And you can also use information around the flow of money to identify the kingpins who are normally shielded from the street level crime. So to unfold this strategy of following the money to prove the crime and disrupt the business model, they adopted the strategy of criminalizing money laundering. Now, previously, there was nothing wrong in dealing with money. Pecunia non olet, money didn't smell. It had no history. Bankers could deal with money wherever it came from. They wanted to turn that around and actually make it a crime to knowingly deal with proceeds of crime or negligently deal with it under circumstances where you should have known that what you're dealing with probably derived from crime. To unfold this strategy, they needed a framework requiring every financial institution, and later businesses and professions like lawyers were added, to identify their clients. To identify by collecting information about each client and verifying some of that information, and then to profile them so that you had an expectation of the business that you were going to deal with them, or do with them, so that you can monitor their transactions. If you open an account for a student, you know that you're dealing with a student, you would have a certain impression of the profile. For an academic, you would have a profile. And if the transactions didn't meet that profile, you needed to take a closer look. And then if you thought there was reason, report that confidentially without informing the client to the authorities, a specific national financial intelligence unit. And if you tipped off the client, negligently or intentionally, you committed a crime. That's the basic framework. The fear of the weakest link that we often encounter globally kind of drove the strategy. It was decided by the big economies, mainly driven by the G7 at that stage, that if they were going to implement this law, everyone had to do it, because otherwise they're going to lose all of the dirty money out of their economies that will go to the smaller countries. So one in, and all in to the same extent, because the system was going to fail with the weakest link, which is the smallest low capacity country. The system was rolled out through standards that are non-binding. The 40 recommendations, called recommendations because initially they were simply recommendations, just ideas before they crystallized into standards of the Financial Action Task Force. This is only after 30 years become a standing body. It's got 39 members at the moment, 37 countries and 2 regional organizations, but they lay down the standards for all 200 plus jurisdictions globally. The standards are non-binding, but following the OECD model, countries are inspected for their levels of compliance, both technically. Do you have the laws in place? Do your laws have the necessary elements in place? And since 2013, for their effectiveness. And have you implemented this law? Is it delivering the results? Are you getting enough reports? Are you seizing enough criminal money from the right criminals? So also effectiveness. These standards are forceful. Though in law they're non-binding, countries don't have a choice. More than 200 jurisdictions have committed to implementing these standards. Countries like China and India and Russia committed to implementing the standards without having had an opportunity to even formulate or influence the formulation of the standards, because they wanted membership of the FATF. And that was 10, 15 years down the line. And the only way to get that was first to adopt the standards and then to position yourself for membership. So this is how powerful these standards were. This would never happen in the United Nations or at a Security Council level. It happened in this space. If you fail to comply adequately, you get grey listed and blacklisted. Now, currently, there are 3 countries that are blacklisted. Myanmar was added in October, but otherwise Iran and North Korea. And then there's a range of countries that are grey listed. And that signals to anyone else dealing with anyone from that jurisdiction that there may be a higher risk. So it slows down trade and credit at an international level, and that economic impact compels countries. Everyone on the grey list is working very hard to get off the grey list, and everyone else is working very hard not to get onto the grey list. So that's the basic outline of the system. Coming to the data, what does this mean? And I want to illustrate it just with one element: client identification and verification. Just a small building block. I think we've all been through these processes. If you want to open a bank account, you need to fill out forms with specific information. So those are the identifiers. What is your name? Might be, what is your date of birth? In some countries, what is your gender? In some countries, what is your religion? In some countries, what is your residential address? What is your employment? Personal information you've got to provide, because the bank needs that to profile you. Of that information, certain aspects have to be verified. Your name against generally an official document, your passport, a driver's license, an ID card, your residential address. I don't know how it works in Spain, whether you need to produce a utility bill, a gas bill, a water bill, saying, well, I'm actually living at that address. How do you prove that you're living at the address? This, over the past 30 years, have caused all types of problems. Firstly, volume and speed, because businesses had to implement this for all of their customers. We're speaking about literally billions of people around the world, with different interactions with different financial institutions. They all have to do the same. Everyone is frustrated about that. You want to do it as efficiently as possible, extracting as much information as possible. Initially, systems were human-based. So you would provide your document to a person behind a counter who would check the document. Whether they're able to spot a false passport and distinguish that from an actual passport, that depended on their skills level. So that brought in data quality issues. Then, of course, changes after onboarding. Once you've opened the account, you may get married and your surname may change. You will certainly change residential address. So some of these fields keep on changing. This is not a difficult exercise done once. It's gone, and you change jobs. The student suddenly becomes a young professional. Suddenly their profile changes. You need to collect information about that. I've only spoken here about individuals, us, natural persons. Just think about the nightmare when you deal with legal persons, because there's a whole raft of different information that you then require, trusts and so forth. And all of this has got to link back to your profile of your customer, and it's a looping process. So first you start with customer identification and verification, then you profile, then you need to monitor the transactions while you monitor changes in the client's status and information, and that depends on their cooperation. And that may require you to collect further information and continue the loop, but from a slightly different perspective. And that was just in terms of that one element, basic complexity. And then they added to that because they expanded what you need to know about legal persons, because many criminals, if you think about the oligarchs at the moment, abuse legal fronts, and they want banks to break through the shells and verify not only who the company is, but who controls the company. Now, that's a very different question. Then, of course, and Louis, your area of expertise, terror financing was added in 2001 to the standards, though, of course, it was added mainly because of the 1999 Convention on Suppression of Terror Financing, but this was the trigger. So in addition, you also now had to screen against UN Security Council sanctions lists. But then they added regional lists like the European Union, and then every country added its own lists of undesirables. Currently, we've got about 1,000 of these lists, not all of them overlapping, with names, with aliases, often in different languages, and with non-Western spelling. Then in 2003, they added anti-corruption as a specific element. And suddenly you also had to check whether your customer is a PEP. A PEP is a politically exposed person. There's a specific definition. It's anyone in a senior political or state executive office where they might be vulnerable to corruption. So all senior judges, not junior judges, all senior officials, not junior officials. And they left it up to banks to decide what's senior and junior. Plus, all close business associates. They left it up to business to decide what's close, and they added, and all immediate family members. And it's for you to decide what is immediate, because a corrupt president would normally not go to a bank in a foreign country to open an account. They'll send someone in the family or someone that they trust that they work with. And that's part of the concept. And countries decided this is too difficult. They're not going to make their own paper lists available. So there isn't a national list of that. It's got to be determined by the institutions who have to comply. Now, just an extract from a UN sanctions list to give you an idea of the formal information that you get. I've extracted there just alphabetically some of the names, but you will see there one name in Western script, then in Arabic script. And you know that the spelling from Arabic into Western script is not stable. So there's a range of spelling. There are things that the UN knows about the person, and then there are things that they don't know about the person. But luckily, they make it available in a somewhat structured form, but not all lists do that. So when you scan your customers against that list, you may actually get a number of hits. I took, for instance, the name of Karate Mahad. If you run that against your database, you're going to get every karate club that you bank. So for that, you need an analyst to look at each of them, and you may actually get an Osama bin Laden or an Usama bin Laden or bin Laden on your customer list. And you're going to get that with every transaction. And you need to make sure that that person is not the person on the list. So you need a raft of analysts who can work through the results of the screening to determine whether that is a valid hit or not. To add stress to the process, the regulators decided banks need to do this much better. And they started to fine banks. Now, that is just from a US perspective, and it's when things rocketed. Now, these standards were adopted in 1990. US laws predated some of that. But until 2011, fines were minimal. And then suddenly, they hit in 2012 HSBC with a $1.8 billion fine. $1.8 billion. And we were aghast. I mean, no one has ever levied that type of penalty. Then, of course, Bank Paribas got an $8.9 billion fine. These are stratospheric fines. Now, these came from the Americans, but then the other regulators sat up and said, but we're not effective if we don't give large fines too. So suddenly the Australian regulator, John, started to hand down fines of 800 million, Commonwealth Bank, for example, 1.2 billion, Westpac, because we need to show we're effective, and the easiest way to do that is to show we're levying big fines. Now, all of this added anxiety and added the need to have systems in place that prevent non-compliance. by large institutions. So we've seen the rise in compliance technology. I prefer compliance technology. Often it's referred to as red tech, but red tech can also include supervisory technology, and it's best to keep them separate. So I just refer to compliance technology for the purposes of clarity. But for example, you get technology making information available to you, taking the UN lists, taking the data of the other 999 lists, taking PEP data, what's known in terms of open data on PEPs, and making that available. So you can run that against your client database every 24 hours, plus every new customer also gets screened against that. Then for all of these analysts, and some of the large banks have thousands of them, you need management tools. So to keep track of who is investigating that Osama bin Laden is the one on the list and not an innocent customer. And then if it's clearly an innocent customer and you now know about it, you don't want to run every check against the same person again. So you want to whitelist some of the names that may otherwise be red flagged. You need a management system. You need automated transaction monitoring based on rules reflecting your profile. So, for example, you would, if it's a student, you might have a requirement that you want the system to flag every cash transaction involving more than 1,000 euros, because that would not be normal for what you would expect of a student. You need technology to assist you to report transactions. Some countries require all reporting of all cash transactions involving 10,000 euros or more. Every transaction, doing that. So every small business, that has to be reported. We're speaking about millions of transactions. You need the systems to do that. And then once it gets to government, they also need systems because they're getting a flood of reports coming in. With the 9/11 attacks, the American FIU FinCEN had data on, it's believed, about 19 of the World Trade Center attackers, but they didn't know that because it was just hidden in all of the other reporting data that they've got. And that caused, well, huge reputational damage for them, but it also diminishes trust in the system. Further complexity was added in 2012. FATF standards were revised in 2012, and they added a mandatory risk-based approach. So until this point, when you had to identify a customer, regulations prescribed you needed the name, the date of birth, the gender, and so forth for each country. You knew what you had to do. In 2012, they said, no, institutions know much better than we do. We're going to move to principles, and we're going to require them to assess their risk and then mitigate their risk. And we'll come and inspect them to see whether they've done that reasonably. So we repeal all of these regulations, we leave it up to them. Now, keep in mind, in the institutions, we've got the banks, but we've also got all the smaller banks, everyone else in financial institutions. We've got the sole lawyers, we've got estate agents in many countries, we've got dealers in high value goods, jewelers, they're all in there. No, they know much better. They know much better. They can do this on their own. And that was a move to the risk-based approach. Every country has to do a national risk assessment. Often it's too sensitive to publish in full. So they publish 10 pages for the private sector, and then the private sector knows precisely what they need to do. And they need to go through the same exercise using those 10 pages. Where they identify higher risks, they need to do more. Where they identify lower risks, they may do less, but generally they don't. And they need to consider things like geography, cross-border transactions, the channels, and so forth. So essentially, it put risk at the heart of the system. And instead of having clarity about how you do CIV, you had to determine your risk, and then based on that, you had to decide what you're going to do. And the same with profiling and monitoring and investigation. Now, there are complexities in this space. Firstly, the quality of your risk assessment depends on your understanding of the risk. So how many small businesses understand terror financing risk really well? They may get the basics, but generally they may not have enough information to really assess that. Plus, every business has a different risk appetite. And some of you may like to scale sheer mountain walls. I don't. But some of you may do. And of those who do, they may do some, but they may not do others. And they look at the equipment when they want to do some and decide, no, I'm not going to do it with this equipment. So there are different shades of risk appetite and expertise. And they all join together when you do a risk assessment. So currently, I've got good question marks, big question marks about the quality of what's being done. But the most important thing, I think, for this discussion is it complicates a one-size-fits-all approach that we normally like for technology, kind of the rule clarity that is helpful. That's been broken up. And instead of serving one market with a product, you now have individual businesses, and some of them very small, that may not share enough similarities to actually use the same general commercial product. Now, there's been movements to some solutions. One is an emerging partnership approach. For years, the state didn't want to speak to the private sector. And the private sector had the eyes on the transactions, but they didn't know what to look for. And government knew what they had to look for, but felt it was too sensitive to tell them what to watch out for. So you had a system that really didn't deliver value because it operated in silos. That is slowly being broken down. And in terms of identity, we've got the move to digital identity. Now, just very briefly on the partnership approaches. We see, for example, in the Netherlands, 5 big banks have started to work together. They fashioned a utility in the middle to scan their transactions, but each bank has sort of its own transactions. The others, it's not shared, it's not a shared database, but the monitoring is shared across the banks. It's a very innovative model, one that we proposed 20 years ago, and the regulators didn't want to approve it at that stage. We've also got in Australia, for instance, a more investigative partnership where they come together and they may decide, let's act against child traffickers. And then they work together on that. It's project-based. And that is also helpful. In Australia, it went one step further because they brought in our national scientific organization, Data 61, to help them to develop a monitoring tool with homomorphic encryption technology that they, from the government's perspective, could insert into a bank system to search the bank system without identifying the bank's customers and without the banks knowing what they are looking for. So it's a black box tool that closes some part of the information for government and closes another part of the information for the banks to do a search across banks to follow transactions within the banking community. But then we have the rise in digital identity. Now, one example, India. India in about 15 years ago was an example of a big developing country that did not have a good idea of who was within its borders. No national identification system. Government had no real means to really interact with its population. So they established in 2009 a unique identification authority and an identification system based on biometrics. And then based on that, with a number that's issued in biometrics that they collect, that we can discuss, they launched eKYC. So it's electronic know your customer or electronic customer identification and verification for AML. This is a big system. From 2009, they've issued 1.35 billion unique numbers. They did it in a fairly unique way because people didn't have the means to verify their identity. So they would allow me to go up to the system and declare I'm John Zeleznikow, and I can commit identity fraud. And they capture my fingerprints and my iris scans. And from now on for the system, I'm John Zeleznikow. That is my identity. So it allowed fraud, but once. Once you're in the system, that is your identity. So essentially how eKYC works, and that's a photograph I took in a small community just outside Mumbai, there's a fingerprint scanner, that little white box. You would go up to a bank agent to say, I want to open a bank account. You would provide your identity number. You don't need the card. If you have the card, you can provide it, but either the number suffices, and you scan your fingerprint. If the number and the fingerprint matches, you get the next question. Do you want the state identity database to pre-fill your biometric information on your account opening form? If you say yes, in drops your name, your residential address, all of the information that they have on you for the bank's purposes, fully verified. The bank doesn't need to do anything more. Customer doesn't need to do anything more. All very convenient. What was a 2-week period has dropped to 7 seconds. Very cheap for the banks. Everyone being happy, except of course the lawyers. So not unexpectedly, they had a privacy challenge brought by Judge Puttaswamy, a former judge, retired, he's now 96. He brought a huge challenge, firstly, on privacy law in India, and the Supreme Court issued a judgment of about 600 pages, finding that the Constitution of India actually recognizes a right of privacy and ordering the government to draft a privacy law. They're still drafting that, unfortunately. And then he followed that up by challenging eKYC because he said, this does not allow options. If you want a bank account, this is the only way in which you can open it. It was a 1,100-page judgment in which the court again agreed with him, caused a bit of chaos because they couldn't follow the system. They had to intervene with regulations while they fixed the law. They fixed the law by allowing you to open up the account using different means. But frankly, it is so easy for the customers to follow this route. I haven't seen a lot of research being done on how many follow the alternative route, but I think it's probably just a few hardcore human rights lawyers that may actually do it, and some NGOs. The rest of the people look at the convenience of the system and they embrace it. Now, eKYC is morphing into digital identity. The concepts are still distinct, but FATF essentially also endorsed digital identity. There's a guidance paper of 2020. They did this basically to enable e-commerce, but they also did it in a broader sense of a digital identity that you can use to verify your identity even while having in-person contact. So they included the Indian concept in their concept of digital identity. And they lifted out 2 aspects, changed the language to identity proofing. So that's where the system proves who you are, or that you are who you say you are, and then authentication. And that's where you come back to, as an existing customer and you want to use an ATM, you've got to prove that I am actually the customer of the bank that you've identified and verified when the account was open. So for that, you get credentials like a PIN, or you now get multi-factor authentication on your phone that works if your phone is not doing the rounds in a taxi in Granada. Then levels of assurance, because not all digital identity is particularly secure. And they said, well, for some small transactions, you may not need a very high level of security, but if you deal with property that's being transferred, real estate, then you want a really secure level. So they allowed flexibility, just illustrated there with US standards, where at the very first level, it doesn't really amount to much. It's basically identity through self-declaration. Level 2 is probably the most general one. Level 3, on the other hand, is one that you can't get without actually proving your identity in person. You can't just do that online. So the standards now allow for digital identity too, and a range of solutions are developing, not only for individuals, but also for companies, legal identifiers, the company directors, unique director identity numbers. So we have increased complexity and embracing of technology in that space. But obviously, we also have the criminals who are pushing back. I don't need to say anything more about identity theft, but have you come across ghost identities? Big issue in America at the moment. If systems allow and employ digital identity means that checks your digital identity footprint, then to figure out whether you are actually John Zeleznikow, they may look at your social media footprint. And if there's a social media footprint, it may recognize you. So if you build a social media footprint by opening a Twitter account, getting that verified, $5, opening up a Facebook account, you can actually create a non-existent identity. And then you tweet and you post pictures, and you do this for a year or two, and it becomes a very secure identity that doesn't exist. So crime syndicates are now specializing in, they've got identity farms where they grow identities based on digital footprints. And that kind of, so synthetically, they grow that. And then, of course, we've got the whole area of crypto or virtual assets that are not really identified up front. But again, with a pushback from technology where there are more forensic companies intervening to follow the footprints of transactions on public ledgers, because at some stage the value's got to be paid out. And at that point, you may actually identify the person who was behind that crypto transaction. So there's an arms race taking place in this space. Now, kind of moving towards proliferation financing, just a few impressions. I don't want you to read the detail there, but this gives an idea of where the system stands at the moment. That is just an extract from the latest round of FATF mutual evaluations, and you will see a very clear line kind of towards the right that's more red, and then other parts that are more green. Now, the parts that are more green test for technical compliance. The parts on the right test for effectiveness. So clearly, if you look at that picture, and that's the whole picture of all 170 countries that have been tested to date and assessed in this latest round, we're doing better on getting the laws in place. We're not doing that well on actually getting them to be effective. A lot of that has to do with capacity. I've just lifted out there some lines on Spain compared to the next country on the list, Sri Lanka. And I think you can see where the differences lie, because effectiveness costs money. So we've got a big global north, global south tension developing in this effectiveness space. And now for the last part. On top of this structure, then was grafted proliferation financing control. So proliferation is the term that's linked to weapons of mass destruction, linked to UN conventions and Security Council resolutions that aim to restrict weapons of mass destruction. And what that means depends on the group that you're from. There's one group that says it's got to be restricted and phased out so that no one's got them. And the other group says, well, it's got to be restricted so that no one else but us have it. And that's kind of the prevailing UN Security Council view if you think who's in the UN Security Council and who are nuclear powers in the world. And weapons of mass destruction is nuclear, chemical, and biological. A lot of the controls in this space focuses on dual-use goods. So the pharmaceuticals that can be used in weapons are also the pharmaceuticals that we use in pharmacies and in hospitals for good. The software that can be abused in nuclear weapon systems can be the same software, and AI is increasingly included there, that can be used for good. So countries have dual-use good export regimes in place. Not all of them very effective, not all of them very extensive, but the idea is to identify these goods and to control their export. Now, the problem is we have countries who deliberately want to undermine those controls. North Korea is one example, and the rest may be politically sensitive, so you can think of your own examples in that space. But basically, they use the money laundering methods of shell companies, of hidden transactions, of front people to hide what they are doing. And that's why it made sense to use the system also in this space. So in 2012, a specific standard was adopted requiring these controls to be used in relation to the UN Security Council resolutions relating to proliferation. Now, essentially, keep in mind the two schools of thought: broad proliferation, narrow proliferation. UN Security Council, they are the haves. So for them, this language focuses currently on Iran and North Korea, not on other countries. That was what was built into the FATF standards. But there's also this broader perspective of anyone who may get this, or where it may be shed into the markets. And of course, then we bring in non-state players that may also get it. They're not in the UN lists. And that may lead to a security council or a global security risk, especially from organizations that are not listed for terror financing purposes. But FATF has been very specific about limiting its focus to the UN Security Council resolutions. And then in 2020, it combined this with a risk-based approach, because until 2020, they said AML-CFT is risk-based in principles, but the UN Security Council sanctions, that's rule-based. In 2020, they said, well, it remains rule-based, but we want everyone in this space to do risk assessments, and where they find out that they are exposed to higher risks, we want them to do more. So currently, we've got all of those regimes kind of interacting. We've got money laundering that kind of overlaps with terror financing, TF, with proliferation financing that overlaps with both, but proliferation financing also goes broader because of the complex, and I don't want to drag you down into that, but there are aspects of proliferation, that financing that falls outside of that sphere. We've got sanctions. And then in the heart of that, we've got this little space that combines proliferation financing and the targeted sanctions against Iran and North Korea. Now, if you think about the complexity of all of this, and the complexity of small businesses having to run this and operate this effectively with the threat of fines, and the large ones, the big banks, I do think that we need to consider what the role of AI is and is going to be. What is currently clear from my research is the thinking around this is still very much in silos, and there hasn't been a lot of deep thinking also in relation to the technology that is required. Now, from the technologies, and I took the benefit there. There's been a book published 2 weeks ago by a German group, that actually touched on AI within proliferation, not proliferation financing. So I used some of what they picked up on, what's needed in this space in terms of objectives or deliverables by tools, translation tools of technical texts. And now we speak about kind of engineering texts, pharmaceutical texts for export purposes. Because the problem is North Korea is not exporting things on dual-use goods. Often they are exporting things that are just outside of the technical scope of what is listed. And once it gets to North Korea, they upgrade it. So you can't simply focus on what is on the list. You also need to understand the technology and you to broaden your scope. And we're speaking about a level of technical knowledge here that's not generally available to businesses. We're speaking about interpretation of fast-changing rules. In February, the whole raft of Russian sanctions happened effectively overnight. This can happen very fast, and institutions need to be able to respond to that. We need tools to assist with textual analysis, also data visualization and analytical support, because there are analysts who are going to look at this. So if they get red flags, they need to be able to combine the technical specifications with client profiles, with an investigative system. We will need visual data, because exports, you may think that you are financing an export from country A to country B, but the ship taking the goods to country B may divert and may go to a third-party country. Now, ships have signals that they send out that can actually be collected and followed, also when they switch them off, because that's an alert, and they do that, they're transponders. So analysis of sensory data on sensors, nuclear tests, for instance, are measured in that way, air quality. Analysis of your customer and transactional records with shipping registries. Where is that ship actually registered? Who is behind? Who owns the ship? Export controls, export rules change. This is complex. And then integration of all of this data, kind of multimodal, because it doesn't help to get them in silos. You need to get them in a way that makes sense. Now, all of this is still early days, because having done that, and that was very helpful to get the German colleagues looking at that closer, they came to the conclusion, we've seen pilots on many of this, but not really more than that, and not really implemented. One of the big problems here is we don't have many examples of sanctions breaches in relation to North Korea and Iran. So we've got SIN data. We've got big transactional data, but we've got SIN data actually on methodologies. And then, of course, what you would have screamed in your minds right from the outset is privacy. Data protection. What on earth happened to that? Well, all that happened to that also in the European Union was this was moved into the law enforcement exception to privacy and data protection. But is that really a comfortable fit on this scale? Thinking about that, and I'm going to leave that slide up, perhaps for discussion. What I tried to provide you with is the broad context. We can't solve all of the problems, but can we solve some of these problems? And this is a simplified example, starting right in the corner with a sanctioned individual. Think of a general on a UN targeted financial sanctions list. Now, clearly that individual is not going to be able to import, export anything. So for that, they need to create, let's say, a front company. Obviously, this will be done through layers. We don't need all 10 layers. Let's just make it, for purposes of a simplified example, one layer. That company will need a bank, and preferably a few bankers, because you want to split your transactions across banks, because banks don't speak to one another at this stage. So that's helpful. And the front company is the one that will have to place the order with the manufacturer is the one that will have to apply for an export certificate, and your front company will need to look like a company that should be legitimately dealing in those goods. So the export certificate, that's given by government, and government needs to have access to enough information to ensure that certificates aren't given for transactions that should not be allowed. The manufacturer is probably going to be the one that makes an arrangement with the shipper, because you need to get this across your borders. Let's say these are big units that need to be transported. The shipper will have a bank. The manufacturer will have a bank. Your front company has banks, and payment will need to be made from your bank to their banks. So there are different banks that will probably need to look at the same information. Those goods will be transported to a warehouse in a third country. Obviously, you're not going to try to export it to a sanctioned country. There are third countries that are more sympathetic. Most of the North Korean flows seems, according to the UN panel of experts, to happen through China, just to make things even more complex. And then from the warehouse, you will need transport, let's say by truck if it's close by, across the borders to get them to where you wanted them initially. So there are various role players here, and they kind of need same information, but they look at it from different perspectives. 30 years ago, if we designed that system, every bank will have to have had its own system, and the government will also have had to have its own system, and the manufacturer. With public-private partnerships, are there ways to kind of join up some of these better? Are there ways to do that without, again, let me bring you to that was a sign at the at a station in India that I thought appropriate, very in the very Indian way. Namaste, you're under surveillance. It's a very Eastern way, but apologies in the nicest way, but you're under surveillance. Is there a way to create a system that will function effectively, that will increase global security? Because we don't want nuclear bombs going off. We don't only want nuclear bombs going off if they fire by North Korea. I think the whole system has become even more absurd since February. That it's so myopic. This can help to build a safer global community, but not at the expense of our personal data. How do we get a better balance and get assuring a system that is effective? And I think as we discuss our way through this complexity, AI jumps out as a solution. But that means also we need to create the conditions for that solution. And does the risk-based approach really provide us with the best basis for a manageable AI system that can provide those solutions? Those are thoughts that, John, I'd like to throw over to you as a technologist expert also. And with that, I'd like to hand the floor to you, John.
Well, thank you. Now, do you want me to come up?
Please.
Thank you for that. Thank you for that very interesting and thought-provoking talk. Now, I've recently written a paper on trying to use, and when we use AI, most people seem to think of machine learning now, although the rules are certainly the very traditional way of using artificial intelligence and the most productive. And one of the questions I asked myself was, what was legal data? And I realised, having listened to Louis' talk, that I had a very different conception of legal data. To me, legal data was data occurring in judgments, legal text, generally free text that has to be massaged and cleaned and transformed before we can use it. But at least if you're using what I had thought of as legal data, then in fact those decisions were being made by people with functions. Now, the real question is, and what we've been talking about, is data that is in no way verified. It is not clean. So the first question, and rather than just giving a set of opinions myself, I'd like to have the exchange. The first question that I wish to really talk about is, what is the quality of the data? How do you know it's accurate? Who has, what are the legal liabilities of the people collecting the data and the people giving the data?
Very good question, John. I think it depends a lot on the data that we're speaking about. And there are different data sets available. So if we speak about national identity data, that should be fairly clean and fairly usable. If you speak about the broader picture, let's say, what is the quality of data that banks hold on which the monitoring system runs, then that is far more broken. But not in terms of the transactions, that transactional data, the $1,000 that's being paid, that would be correct. The problem comes into analyzing and building into a system what you think is problematic and that should be flagged. What we've seen is millions of reports streaming into government with a trickle of convictions and then a smaller trickle of asset confiscation happening. So the link cannot be made well between the quality of what is reported. Are the right things being reported into the system to deliver what the system wants to deliver? Because something happens in between. The banks believe they are doing the best they can to mirror in the systems what humans in the banks would have reported. But whether the human reports the right things or not, that's the big question. The criminals won't tell us, yep, no, that transaction was spot on, I was trying to launder money there. So all of the facts in this space is contested. With weapons of mass destruction, we have a UN panel of experts who lift out examples. All of those examples are contested. They lift out specific countries. The countries push back. The finding in the end is a political finding. We don't know what the actual facts are. They are political facts. And that complicates the system as a whole. But in terms of the specific individual bits of data, I think most of them in the financial space will be fairly verified. The problem lies in making this jump as to connecting the dots and what they might mean from the perspective of AML, CFT, CPF.
Other question is evaluation. Does anybody monitor how good the answers? Evaluation. Does anyone monitor how good the solutions are and what the negatives might be? For example, I think I've read, because of getting names wrong or something like that, that there are families where the authorities have lurched into, often with machine guns and things like that. How regularly do the authorities using such systems get it wrong, and how careful are they with evaluating action beforehand, or do they go for a fully automated approach, which is the data has told us this, hence this must be right?
Very, very good question. Very good question, John. Thanks, Fernando. The problem is that we're dealing here with things that happen in a national security space. So it disappears into a black box. The banks are not allowed to share with us what they report to the National Financial Intelligence Unit. The National Financial Intelligence Unit gives no feedback to banks on specific reports. They don't tell them, this one is good, that one bad, we investigated it, that was a waste of time. So for 30 years, there hasn't been a feedback loop. They may give general feedback, like, yeah, we could extract value from a percentage of reports that you file, but so that makes assessment difficult. Then it's in this National Financial Intelligence Unit. Often those that I interact with are frustrated because law enforcement, they feel, aren't making appropriate use of their data. So you may get a report that's filed, and you may get machine guns in an innocent home late at night, but you can't connect the dots. They may or they may not be connected. Like with the reports around 9/11 being in the FinCEN database, that may translate or may not. We need much more transparency and kind of a research engagement to actually follow this into the system. And that the system itself is not particularly interested in the answer. And we've seen empires being built around these data holdings. And as an academic, I've often wondered to what extent the system is actually about countering money laundering and terror financing, or in this kind of proliferation financing, because it's not really aimed at the main problem. So is this a huge data collection exercise? But then I think I'm probably too suspicious, because it doesn't seem as if governments are actually using the information effectively for any other purpose either. So we can say with confidence the system isn't working, but we can't say why not, because we're not allowed entry. So for long, I advocated for the Financial Intelligence Unit to be placed under an Inspector General of Intelligence. In Australia, that has happened, but the Inspector General of Intelligence has a very, very narrow focus. So this does not really get unpacked appropriately.
So as far as I understand it, one of the important things is to get the banks performing more effectively. And but on the other hand, the authorities are not giving them any feedback on their performance until they get fined for doing something wrong.
And even then, they don't get feedback about you filed bad quality reports. They get fined for not having filed the reports. The authorities don't get fined for not using the reports. If they've been, there's been a big fine on Commonwealth Bank for failure to report 50,000 transactions. I'm not sure that any of those transactions he filed, that information would ever be used. And still they ended up with an $800 million fine.
So,
Yeah, no, I just wondering, because I want to know because I was involved into European projects about the use of DI against terrorism and terrorism. And we never focused completely on money laundering, but we try to follow the day of cryptocurrencies.
Right.
Yeah, in that case, that you have exposed it, it's very good to join the talks.
Absolutely.
That is very useful. But at the end, we have exactly the same problem. Because we never know exactly who was behind this code. It's exactly the same that you are getting information and you go to an offshore. You don't have the opportunity. But it's useful in cases where, for example, you can make it all the problem is really complicated. You can make it easy if you can take it all the companies companies out because you have all the data from the register. You know who is the person, the human who is behind this person. That makes it easy. So the reason for my wondering was, do you have any experience on real cases about the use of that?
We know that the very large banks, so the world's biggest banks, HSBC, Santander, so forth, kind of the Wolfsburg banks, they often speak about using AI, but a lot of that is commercial in confidence. I'm trying to discuss that with them at the moment, and they're very careful, and I understand that, I respect that, but as a result, we have big companies involved, Thomson Reuters, certainly SAS, who often say, we're in this space, this is what we offer. I'm not quite sure how far that goes. And then, of course, in the space that you worked, there are Chainalysis, Elliptic, as the crypto forensic companies, and they probably use elements of that, because otherwise, you know, the open blockchains of Bitcoin and Ethereum, that's big. And to mine that, I assume that they are using artificial intelligence tools or AI technology-based tools. On our being careful, I don't think we really have AI yet. But we've got the tools, we've got the technologies. It's not yet unpacked in that kind of broad sense as it was envisaged, and the extent to that. So it's the extent to which it's used for marketing and the extent to which it's really kind of crossed the AI threshold into decision taking. I'm not so sure about. I think it's still more technical, but those are areas that I'm aware of where development is taking place.
Just a few questions on the last topic. I was wondering, two issues on artificial intelligence applied to loans. First is the dialogue or conflict between the I transparency and I understood as a commercial secret to be protected. And then how can those two extremes in dialogue? And one thing that you mentioned at the beginning on data, you said banks can wonder about religion or age or something. As a bank, I can be interested in age, but what is interesting on religion when I am dealing with a loan from a European perspective would not comply with the minimization principle.
Very good questions. The commercial in confidence and transparency issue, that will remain. In terms of financial institutions, I think there's a solution in empowering the supervisors, because the bank supervisors, there are no commercial in confidence walls that a bank can create in relation to its supervisor. It's fully transparent to its supervisor. So that's why the development of supervisory technology and the ability of supervising bodies are so important. They will have to also implement the work that you're dealing with around any AI type of tools, ensuring that they are appropriate, that they're not biased, because civil society won't be able to do that. And the competitors in the banking industry won't be able to do that, but the supervisor can. Regarding the second question, you're quite correct. It's a sensitive matter. It is countries in Southeast Asia that I've come across, Indonesia, for example, and often more Muslim countries where the declaration of religion is required, and often it's also on the identity card that's issued. All I can do is take note of that. From a perspective of terror financing, of course, that does raise questions, because in the past, when we looked at funding of the IRA in Ireland, more attention would have been given to people of certain faith, depending on which flows of money you were looking at into that conflict. So where conflict is faith-based, it becomes problematic to consider how to weave religion into the monitoring mechanisms, because it's more difficult to argue it has no relevance at all when you think about risk. But otherwise, I think we all share a sense of discomfort. Same around gender. I specifically mentioned those examples because they are examples that are available in laws and approaches in different countries.
Works. I'd like to ask, thank you very much for the speeches. I really enjoyed them, and they make me think a lot. And one of the, I'm going to ask about one of the big limitations of artificial intelligence, which is the human factor, which you will find at the end of the day, because there will be a person applying all the rules, bringing all the red flags, and interpreting all data. And I think that this all these systems involves a big problem of financial stigmatization for false positives. And this leads us to human rights protection, because efficiency in the implementation of the rules is not the only goal, but also not punishing people that do not deserve to be punished. So banks will not invest a huge amounts of money in financial investigations, because that's not what makes money for them. They want to do business, they want to earn money, and they put human resources to look for bad people just because they are obliged by law, and they do not want to get fines. But that's not their main purpose. They're not interested in protecting human rights. They are not interested in protecting public order, or they do not want to contribute to the committing crimes, but basically they're interested in making money. And when you talk to people working in the banking business, implementing these artificial intelligence rules and interpreting red flags in the banks, what they tell you, what they've told me, is when you find, if you have a huge client and you find red flags, you put time on research because you want to keep it. But if it's a normal client and you have 5 red flags out of 10 items, you don't get rid of it. You don't put time and effort to research. You just say, we have to close your account. And we can move along, and that's all. And so you ask banks invest in artificial intelligence and to put human resources to provide the right service when states, even states, prefer to have general rules and apply them without care. And this is not working quite well, and I think I prefer to talk. Without bothering you with this noise. So, I'll put the example of the Hawani case. The sanctions against Syria by the European Union. Just by the fact of being an important business person in Syria, you're sanctioned, whether you support the regime or not. Because the European Union thinks that if you do business in Syria, if you have banks and enterprises in Syria, you cannot keep them without having a good relationship with the government. So you don't have to prove that you have supported the government or proliferation or anything or terrorism. No, just for being there and doing business there, you're sanctioned. And that was considered compatible with the rule of law by the European Court of Justice. Or this year, beginning of this year, in the Sabra case, a guy who was now based in Lebanon, who owned a couple of enterprises in Syria, but that had supported and funded an opposition NGO that was helping people in Syria and had criticized 1 or 2 times the Syrian government, said, look, you cannot sanction me because I'm not supporting this government, though I am a business person. And the European Court of Justice said, even if the regulation had not changed, that would be arbitrary to sanction this person. And therefore, it goes against the rule of law and the basic principles of the country that protects of the European Union in the protection of human rights. So if even the European governments prefer to have this general rule, this all-encompassing rules, that punish people that maybe are not guilty of anything, how can you ask the private entrepreneurs, the banks, the private business to apply these red flags in a taking care that there are no false positives? Don't you think that this is one of the great weaknesses of applying artificial intelligence to the detection of terrorist financing and proliferation?
I'll go further, and I'd say I think that's one of the great weaknesses of the system as a whole. Because on the assumption of the regulators often is banks do this because they want to keep these systems clean. That's a constructed assumption. In the 1980s, with the adoption of these recommendations, what was essentially done was banks became enlisted surveillance agents, unpaid. That kept at arm's length. Again, that brain-eye idea. They were forced into this relationship and role. And then in some countries, I don't know whether you know, John, but in Australia, about 10 years ago, our National Financial Unit, that's also the AML regulator, was a government agency funded by government. And government decided, no, it's actually a service delivery agent to the private sector because it helps the banks to keep these systems clean. So taxpayers shouldn't pay for it. The bank should pay for it. And they turn the whole model around. We don't pay for Austrac. The more reports you file with Austrac, the more you have to pay towards their budget. And it's a topsy-turvy world where the data collector for national security is actually created. A fiction is built to say, but actually, it's actually a service delivery organ, and it does good for you as a bank. So there is a fundamental assumption underlying the system that's problematic. And you're quite correct. You've now pointed to debanking or de-risking. Now, I've been following that since 2006. because I'm interested in kind of weaknesses in the system. And for me, that's why I'm focusing on low capacity countries. Kind of those are the issues that challenge the system. And I think the system can do good, but not if it does not factor in all of these negative and consequences and unintended impacts. But that brings us back to the question of AI. I don't think every bank should develop its own AI. I think government should lead the process. I think we should learn from that public-private partnership idea and rather work together to join up a system that can be made available. I'm not that worried about banks because they got money. I'm worried about the single stockbrokers, the single law firms, the single estate agents, the money service businesses that service the poor, the remittance agents that are being debanked, the virtual asset service providers. I work with them in Australia that get debanked because they've deemed too high risk. I'm worried about them. And I think these systems should be provided because the function that they perform is not a commercial function. It is a public function in terms of crime combating and in terms of global security. Why should this burden be placed on them? And I think if we get that right, we may move towards a better system. On AI, I just want to mention, especially in this space, there's another complex element. I've spoken about dual-use goods. AI is developing kind of question marks whether it should go onto the dual-use goods list, because AI will be used in smart weapons and smart weapons in this space too. So there are debates at the moment. I think next week in Oxford, there's another discussion about that, but basically AI and weapons of mass destruction, not in controlling them, but actually as part of it. And that is also something that can't be left to society to solve. We need government to come to the party and work together with all of the parties. But in that, I think AI gets better the more data it can leverage if it's the right quality of data, which means it feeds off our data. And I want to see data protection and privacy being a much stronger part of this discussion than we have had to date. And I'm seeing these discussions literally in silos. I see the lawyers having discussions. I'm seeing the technologists having discussions. I'm seeing, especially in proliferation, the technologists, because we're not nuclear scientists. So the nuclear scientists are now training banks what to look for on money laundering, but they don't understand the laws and the systems. And I'm seeing a highly problematic system actually developing from the space. If you're in, just one last point, if you're in a position of a bank, if you hold the bank account of the University of Granada, from a money laundering perspective, it would probably be a low risk account. From a proliferation perspective, it's more complex because that depends on the type of research that's being done here and where postgraduate students may come from, what the research collaborations may be. How much of that do you think your bank understands or has asked before? And will that mean in future for anything on AI that you actually need to report it to the bank, to the university, to report to the bank in order to manage this risk? But this is a seat of technology. What's happening in computer science, what's happening in physics, what's happening, I'm sure you've got pharmaceuticals in biology. I think there's been a craziness in just adopting the system and grafting it onto AML CFT as if it's going to work as easily as that. It's complex, and for that, we need to work together. If we all agree that weapons of mass destruction is not a good thing, and if we agree on that, we also need to agree if it's a bad thing, it's a bad thing in whosever hands they are. You're equally dead, whoever fires or explodes the nuclear bomb, not only certain countries on certain lists, but that's my personal perspective.
Sharif University in Iran is on the list of sanctions just because of that. And all professors and I mean the whole university is in a different section because they researched in an armed program for the Iran army. Not in the nuclear program, but just they built ships for that.
Because these controls extend to all systems supporting and all delivery systems. So it's really, it touches a lot of technology that we normally work with at a university. And yet we haven't seen a lot of academic involvement in this space. And that's why I grabbed this opportunity. I'm also grabbing it in Barcelona because I'd love to have a broader group of people just kind of thinking about this and thinking about technology and starting to do work around that. We have a window of opportunity as the system unfolds. Countries, I think we have about 15 have now done national risk assessments. I haven't seen the regulations drafted yet being done around private sectors. This system is emerging. So we've got a window of opportunity to help to fashion it before everything crystallizes.
Yes, I was going to say, at Victoria University, we have to report on all of our research students who come from certain countries. And I had an Iranian student doing a PhD on online dispute resolution. Louis knows her well because he's actually written some papers with her. And the research she was doing was absolutely no use. Her father is a member of the Iranian parliament for the opposition, okay? And nevertheless, one had to report on her all of the time exactly what she was doing. She's now got Australian citizenship and is a postdoc, so that may have changed, but the whole, who we collect data on, how we use it, is a really important issue. But the one thing I was almost going to say, and you did say it earlier on, the talk, before you talked about weapons of mass destruction, had very little to do with AI, because there weren't any, it was a collection of large amounts of data, absolutely. But none of it was being analysed as far as I could see using AI. And none of the issues when you use AI on large databases, like explanation, like evaluation, like transparency, have even been discussed. And, you know, the whole issues of national security and transparency evaluation is a really important issue for far more than AI. It's just for how to analyze data.
Briefly, a bit of off-topic question that I did not miss to mention the data property. But I was wondering, in your opinion, to which should pertain this ownership? To the one who generates the data, the one who collects, the one who processes data, all of them, for the user. Which would be your position on that? Personally, I do not have it clear at all, so I would like to hear.
Personally, I would want it to reside with the person who generates the data. Certainly not the ones that collect it, but that's part of the problem. Unlike other goods, data, the same data can be owned by different parties, and I appreciate the commercial rights in that, but I still think that my rights as the producer of the data should override theirs. And that's why I'm in favor of open data and me being able to instruct those who collect my data to delete the data if I want to move away and they don't have any need of my data any longer. To delete it so that I can, or transfer it to another provider that I rather want to deal with in this space. We spoke about banks this morning and kind of the bank regulations in Australia, and I think here too that allows you to move with your data from one bank to another, so that you can keep, for instance, your the credit score that you built up with one bank and can use it to move to another bank.
And this about the debate that we had, it was very interesting because we made the jump from a criminal investigation to a security issue. And I think it's not exactly, of course, not exactly the same context, but also the use of data and AI because probably in a criminal investigation, I will have more boundaries and more concern about the use of particular data. But in a security issue, probably for the Secret Service, I will not have a problem. That is something that we have in one dealing with that combating problems. That is, if we cross data from a deeper, for any police, it's quite easy to get all the information in one.
Yeah.
The question is how to go to approach and you can justify the use of that kind of data. Because not all of them are legally actually used. But for the security teams, it will be completely different. The Secret Service, I protected, I say the national security. It's something very important and the scope is completely different. And I think also when we are going to use that kind of tools, I think the people do that. I mean, I work with the European Commission with that kind of ethical and legal issues, and normally we make a big difference of approach of what is the concept that we are using that kind of tools, what is the proposal of course, and that kind of thing. That is thing, because we made in the discussion, we made a gap very quick between the criminal investigation to a national security issue, and I think it's a big step between the issue.
So, if you look at that brief scenario, one way to prevent all of this pain is to have shifted everything to the government body that provides the export certificate, and provided them with access to the financial intelligence data, and incorporated all of this into the certification process without burdening the private sector with kind of the risk management of this, so that UN Security Council screening, name screening can run in the background, and that's all that's required. Personally, I think that would have been a more appropriate solution. And they could have operated purely within the kind of national security space, which they already are, given what they deal with. But I think, unfortunately, in this space, we have governments that actually privatize a lot of the national security obligations. And I'm not sure it's effective. And in terms of data, I think this may actually be doing damage to our data rights without providing us with increased levels of security. And organized crime has not disappeared despite this raft of rules. Terror financing is not the one that's preventing terrorism effectively. So there's a leveraging of financial data in this space in a way that I really think requires a rethink and recalibration. There's benefit in doing that, and if you speak to the people who would push back on the idea of the export controls, they'd say, but governments don't have this ability. Private sector has got much more ability, and then you need to push back and say, well, define private sector, and how have you ascertained that? How have you tested that? Because generally all they think of is the big banks. But I don't know how many regulated institutions there are in Spain for these purposes, but it's probably between 20 and 40,000. The banks are the big players, but they're a handful of examples of the institutions that have to comply with these rules and that will now have to sit down and do a risk assessment and think about kind of the vulnerability of these systems to support trade with North Korea, which I think if you ask most lawyers, they'd be hard pressed to, and real estate agents to kind of connect the dots.
At the end, it's a balance of risk that we wanted to take. I mean, I have one situation because we were developing the EI, and it was an alarm 5 from 5 in France about terrorism. Then there are many that take the tool and they use it. And it was in RTL 3, I think, or 6. That's bullet risk. I don't think we have to have, I mean, as a citizen of a country, I don't think we have to take that kind of risk, putting in danger exactly what is the privacy rights. I know that at the end it's a matter of issue and freedoms, you have to make the balance. Probably in a particular situation, I would say protect security and the physical rights, but at the same time, when they work with the ideas, that is really complicated. The police forces, in a way, they have a particular, they are training in a particular goal, and the main goal for them is security over everything. And we have seen when we have a terrorist attack, I mean, the restriction on liberties are very big. So it's quite tricky. I mean, it's quite complicated to have a solution for that. That is, from my point of view, that's very important that you have an ad hoc solution for each problem that you are finding. And that is a good way for the one in general. From a criminal perspective, that you are fighting with the rule of law. Yeah. And you can use it. It's a tool that maybe the thing is.
Right.
Thank you very much. Really, it is amazing that we could stand the debate for hours because there is a very interesting topic and really to create a balance between system effectiveness respect of fundamental rights. Using AI in this field is challenging. So I thank a lot to have here Louis de Koker and John Zeleznikow for participating and contributing to this talk. All the audience. I think that if we don't have more questions, we are going to finish for today. And I hope that this bridge that we are creating today with Louis and John is going to grow because it is clear that it is an interesting topic for our research unit, for all of us. Thank again. I hope that you have a pleasant stay in Granada, even if you have to go today. Or yes,
Yes, we are.
But I hope that you come back soon and we can restore this debate.
Well, I really look forward to staying in touch. I'm very thankful to you for the invitation, Begonia. Again, thank you for all the arrangements, Fernando. Great to meet you all. I look forward to continuing the discussion also online and specifically also around the Security Council resolutions. Perfect. Thank you so much. And thank you, John. It was great to join you here.
Thank you very much. It was great. This is